Hey, so in this video, I want to talk about when not to amend your revocable living trust. So I'm Paul Rabelais. I'm an estate planning attorney helping our clients get and keep their legal affairs in order. And as I make these videos, you may have seen other videos that I've made on YouTube or somewhere. I just want to remind you that there's really three sources for these videos because I come up with new content every day. One of those sources is just my 29 years of experience helping thousands of people. So I made a video a couple of days ago, 10 provisions that should be in every revocable living trust. That just comes from years and years of helping people. Another source for these videos is things that happen and questions I get asked throughout the day. So the video that I made that was published this morning was something to the effect of, do Christmas and birthday gifts affect the Medicaid transfer penalties? And then there's another source of information for these videos, and it's the comments in the comments down below. So this video is based on a comment that somebody made, and they asked a question. And look, I'm going to be upfront with you. I don't and can't answer every question that's asked in the comment, particularly when somebody's asking some specific legal advice. Sometimes I'll get questions in the comments below like, "Hey Paul, my dad died and my stepmother went to the bank and cleaned out his account. Can I sue my stepmom?" I'm not touching a question like that with a 10-foot pole. So now a question like this, I can make another video and generally cover the topic. So just be aware, I try to respond to many of the comments, but some of them I just can't for risk of someone me not knowing all the information and someone relying on a piecemeal piece of advice. Okay, so in a comment I read, I think it was this morning or last night, Scruffy, great name Scruffy, wrote, "After I set up a revocable trust and hopefully have everything covered, how much maintenance is there on the trust? If I decide to change provisions on it later, do I have to go through the legal process and pay the lawyer again and again and again every time I make a change?" And I emphasize that again and again and again because just reading between the lines, I sense that he doesn't want to go back to the lawyer again and again and again every time he wants to make a change. So before I get into that, let me just remind you, I publish these videos every morning, 10 a.m. Central Time. So make sure you tune in right around then to check them out. Also, make sure you hit the subscribe button with the notification bell. If you've already subscribed, thank you. That's awesome. Thumbs up would be great. And then comments below are fantastic. So enough there. Okay. So to describe when a revocable living trust should or should not be amended, I'm going to give you an example. So let's say Alvin and Charlotte set up their joint revocable living trust. And in general, the trust says, it's all for Alvin and Charlotte while they're alive. It says when one of them dies, it's all for the surviving spouse. It gets more specific than that, but that's just the gist of it. And then it says after both Alvin and Charlotte both pass away, then the trust assets are to be divided up among their three children equally. And maybe they designate one or two or all three of their children as the trustee or co-trustees to see to it that the assets get divided up among the three children who are the principal beneficiaries of their trust. Okay, so here's when Alvin and Charlotte don't have to go back to the lawyer again and again and again to make changes to their revocable living trust. They don't have to make changes to their trust and incur a legal expense when they sell their house, when they buy a new house, when they buy some rental property, when they buy some stock, when they sell some stock, when they set up an investment account, when they start a business. So maybe what you're starting to realize is that when the trust assets change, that's not a time where someone typically has to go back to their lawyer and amend their trust. What people need to do who have a revocable living trust is just remember that when they acquire a new asset, they need to acquire it in the name of the trust, but they don't need their trust lawyer or their estate planning lawyer to do that. So when they buy a house, whenever someone buys a house, they go to a closing at a title company or a real estate lawyer's office, and they need to just simply, before all that paperwork gets prepared, they need to tell the title company, hey, we want to make sure we acquire that house in the name of their trust, in the name of our trust. So they just title it in the name of their trust. That takes care of it. So the trust assets typically are not specifically itemized in the trust instrument. So there's nothing that needs to change in the trust instrument when the trust assets change. If somebody buys rental property, they just tell the title people, we want to buy this rental property in the name of our trust. Here's the name of our trust. If you open up a new investment account at Fidelity or Charles Schwab or really any financial institution, just open up the account in the name of the trust. You don't need an estate planning lawyer to do that. Okay, so you can buy and sell assets in and out of the trust all day long without needing to amend your trust, without needing to, as Scruffy said, again and again and again, pay the lawyer. All right, so when do you have to go back to the lawyer and make a change to your trust? Really, two main circumstances. One is when you want to change the distribution schedule of your trust assets when you die. So if you change your mind after you set up your joint revocable trust, living trust with your spouse, and you change your mind and you say, you know what, we don't want the assets to go to our 3 children equally. We want 60% to go to this child and our other 2 children will each get 20%. Well, if you're going to change the distribution schedule, that's going to require a trust amendment. So typically it requires you to incur some legal expense, and a trust amendment gets prepared that says we're hereby amending paragraph 2.3 to say that upon our death, child 1 will get 60% of the trust assets, child 2 and 3 will each get 20%. So that requires a trust amendment. If you want to change who the trustee or co-trustees are when you pass away, that will require a trust amendment. Maybe you name your oldest child to be the trustee when you and your spouse pass away, but then your oldest child maybe incurs a drug problem. And so you don't want that child to be the trustee. Maybe you want children 2 and 3 to be co-trustees. So that would require a trust amendment. Think of needing to make a trust amendment just like if you left everything in your name and you had a will. It's doing trust amendments are similar to changing your will. A lot of people do go back to their lawyer when they want to change their will and change the distribution schedule of their estate when they die, or if they want to change the name of their executor who will guide the family through the court process and make sure everyone gets what they're supposed to get. Okay, so I think, because I've gotten that question many times over the years, and I think there's this assumption that people make, which is a little bit false or a lot false, that anytime you get something new, you got to go back to the lawyer and you got to change your trust. Really, that just isn't the case. So now, some people don't want to trust, and that's okay. And so for people who don't want to deal with the hassle of having a revocable living trust, and that's okay. But to base that decision on the fact that you think you'll have to incur legal charges every time you either acquire or dispose of a new asset, that's just not by itself a good enough basis for not wanting to put a revocable living trust and have your family get the benefits of avoiding all the court supervision of your estate settlement when you die. Okay, so there you have it. I want to make sure that you do hit the subscribe button. I've already asked you that. I'm not going to ask you again. I'm not going to waste your time. Maybe I'll say thank you if you've already subscribed. Thousands of subscribers now, really trying to build that base and trying to educate as many people as we can on estate planning topics. That's it for today. We'll see you tomorrow, 10 a.m. Central Time every day. Y'all have a great day. Take care.